Good afternoon, everybody. Thank you so much for joining us for today's talk. We'll be starting shortly at about 3 p.m. For those of you who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Trademark Infringement and Passing Off. My name is Caroline Ng. I'm a paralegal with Mawing & Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Mawing & Associates is a mid-sized law firm that was founded in 1985 by Datuk Ma Huing Hwai. Our able team today comprises of 22 lawyers and a support team of 19. Datuk Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, which includes litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, and a department focused on servicing the needs of individuals and families. These groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWK online talk series. By way of background, we have actually been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, as well as in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event that you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details of that will be given to you at the end of this talk. We have two speakers with us today, Leslie Lim and Hannah Patrick. We will be concluding today's talk with a Q&A session. Allow me first to introduce to you Leslie. She is a partner at the firm and is experienced in general civil litigation matters, drafting corporate agreements, as well as sports law. She was also nominated for the Women Lawyer of the Year category at the 2020 Asian Legal Business Malaysia Law Award. Our second speaker, Hannah, is a senior associate with our firm and is experienced in the areas of general litigation, construction law, and debt recovery. She was admitted to the High Court of Malaya in 2013 and to the High Court of in 2017. As mentioned earlier, we will be having a Q&A session at the end of this talk, so please post your questions into the Q&A chat box at the bottom of your screen. Here are the top points for today. We'll be going through the infringement of trademarks, thought of passing off, enforcement of exclusive and defenses available to an alleged infringer. Leslie will be taking on the first and third points, while Hannah will be taking us through the second and fourth points. Over to you, Leslie.
Thank you, Carolyn. Good afternoon, everyone. My name is Leslie Lim, and on behalf of the firm, as well as the intellectual property team, I want to welcome you to today's webinar. Carolyn has shared that we will be covering 4 top points today, but before we jump into it, I would just like to start with a very quick introduction, particularly about intellectual property. But in a typical lawyer fashion, I'm going to start with some disclaimers. To start off, that you will see that in our slides, there are several images, and please know that they are for illustration purposes, taken from certain websites which provide royalty-free images. Our firm does not claim ownership rights over these images, and we have attributed them to their original owner and writer. You will see the sources are quoted at the bottom of the slides, and there are a fair bit of information that we will share, which are taken from legislation or from the governing bodies. So first and foremost, to start off, what is intellectual property? So according to the definition by the World Intellectual Property Organization, which we refer to as WIPO, IP refers to the creations of the mind, and that's inventions, literary and artistic works, designs, symbols, names, and images. But most importantly, I think we always try to share with our clients that it is important to recognize that IP is an asset. It can be an asset to your company, it can be an asset to your business. It is something that is of value, although it's intangible, but an asset nevertheless. There are different types of intellectual property protection in the world, 6 in particular: trademark, copyright, patent, industrial designs, trade secrets, and geographical indications. We have covered just in IP protection in general in some of our previous talks. Feel free to head over to our firm's YouTube page and you can rewatch the videos at any time. But for today in particular, we'll be covering on trademarks. So again, before we delve into infringement of trademarks, it's also very important to understand what exactly is a trademark. There's a very long definition there. I've highlighted the important words in bold, some in red. You see, trademark is a sign that is graphically capable of distinguishing goods and services belonging to one party as compared to the goods and services that belong to another party. So you'll notice here that the definition refers to a sign, and we're all very familiar with the different signs that you see on the slide at this moment. You know, your favorite car, your favorite search button, your favorite superhero franchise, your favorite coffee brand, perhaps. And previously, the legislation that used to govern trademarks used to be under the Trademarks Act 1976. But quite recently, in 2019, we've seen the enforcement of the Trademarks Act 2019, where the definition of trademarks has been expanded. And you see again there over in red color, a sign is now not just a sign, but encompasses things like shape of goods, their packaging, color, scent, hologram, positioning, sequence of motion, or even a combination of all of that. So it's become very wide already under the new act. I can start on the first top point, having given you an introduction to IP as well as trademarks. So I'll jump first into infringement of trademarks. And over here, we have this brand, which I'm sure is well known to most of you. If not, I'm sure you've seen it in shopping malls around Malaysia. It's a frozen yogurt from Spain, and it's pronounced as Yao Yao, apparently. Over here, you see another brand, which belongs to a shop that just launched in Ampang about 2 weeks back. I will leave you to have a look at both at the same time. So the new shop at the bottom, the first alphabet apparently is not an L, apparently it's a capital I. So it's capital IL dot, capital IA dot, capital IO. Don't ask me to pronounce the word because I don't know how to pronounce it with the capital I. But what you will notice, the key difference between the two is that the logo on the top has a TM over there. It is a registered trademark in Malaysia. At this moment, it appears that the bottom logo has not been trademarked yet, perhaps. And I suppose the question that I'll then pose to you at this stage is, do you think that there's been an infringement of Yao Yao's brand, Yao Yao's logo? Yao Yao's mark by the new brand at the bottom. Here is a photo of the two shops side by side. The one on the left is the store, Yao Yao store in Mid Valley Mega Mall. And the one on the right is the store in Ampang that has just opened. You'll see it's everyone celebrating its opening over there. So again, I leave it to you to ponder whether you think there's been an infringement by the blue on the green. So let's look into what the Act actually says about infringement. Section 54 provides that a person infringes a registered mark if he uses a sign that is identical with the trademark and he did it without the consent of the registered proprietor. And further definition, if a person infringes the registered trademark without the consent of the proprietor, he uses the sign in the course of trade, and that mark that has been used is either identical or similar, and it has resulted in a likelihood of confusion on the part of the public. What exactly does it mean when we say uses a sign? The Act provides for several examples. It can be used when you apply it to goods or packaging, offer or expose the goods for sale under the sign, puts the goods on the market under the sign, you stock the goods if you offer supply of services. If you import or export, this is quite an important point for later, import or export the goods under that sign, uses the sign either on an invoice, catalog, business letter, business paper, price list, or any other commercial document, or if that sign is used in advertising. So to simplify and to summarize what the Act has provided, in order to establish infringement, first of all, the claimant must own a registered trademark that the infringer has used a sign in the course of trade, which is identical to or similar with the registered mark, and that usage has caused a confusion on the part of the public. Here's one example of the case of Danone, and they filed a suit against Huatai Industries Berhad. It's a 2010 case. And Danone is a group of companies incorporated in France, and many will know their chocolate chip cookies, Chips More. And sometime in 2001, the plaintiff discovered that the defendant, Huatai Industries, was selling cookies with the name Chips Plus. And so plaintiff wrote to defendant and told them, please cease and desist your unlawful act of manufacturing and selling chocolate chip cookies using packaging that is similar to ours. They then claimed that Chip Plus's trademark had infringed their registered mark, Chips More, and that there was passing off. And when we went through the judgment, the judge actually detailed out his observation. And the judge said this: I had the benefit of seeing and examining the marks, both marks, and this is my observation. There is an identical phonetic representation when we talk about the prefix chips. And then there's similar imports when you look at the word plus and more. One is Chips More, one is Chips Plus. And then both omitted the space between the two words. And then there's the way the first alphabet is capitalized, the C and the P and the C and the M. And then just the style of the letters in general. So these were the observations of the judge. And the judge then held that, first and foremost, that the certificate of registration and the renewal certificate is conclusive evidence to prove that Chips More's trademark is valid. And again, in bold, you'll see in the middle, in the present case, there can be no doubt that there was indistinguishable phonetic representation on the prefix chips, whereas although plus and more are two different words, there was sufficient resemblance in idea. So the true test is whether the totality of the trademark was such that it's likely to cause mistake, deception, or confusion. And having regard to the totality of the circumstances of the case, and considering the appearance of the two marks, remember just now the judge observed there was different similar styles, the mark Chips Plus is found to resemble Chips More and is likely to cause confusion. And then on top of that, what Danone did is that they adduced evidence that they had expended huge sums of money to promote and advertise Chips More, hence why all of us are familiar with the brand. And that has led to Chips More becoming distinctive to their company. As such, Danone was entitled to exclusive use of the Chips More trademark. Yeah. Here's another case, Lau Chi Yong, just to share what are some of the factors and considerations that the court looks at when trying to determine whether or not there has been an infringement. And in this particular case, although it's under the Old Trademarks Act 1976, here are some of the things that the court looked at, that whether or not the mark is identical with or nearly resembling and likely to deceive or cause confusion, that the respondent is not a registered proprietor or a registered user, that the offending trademark was used in the course of trade, which means there was commercial benefit derived out of it, and that the respondent was using the offending trademark in relation to goods and services within the scope of registration. So if we go back to, say, the chips ball example, both were in the same scope of goods, which is basically not just food, not just biscuits, but specifically chocolate chip cookies. I'll pass the time over to Hannah to take on the second talk point.
Hi, everyone. Thank you, Leslie, again for introducing the concept of trademark and trademark infringement. So my part here will be now on a situation where there is no registered trademark. You see earlier, under the Act, if there is an infringement, you are able to use the Act to act upon any infringement you see in the market. When you encounter a situation where you feel like your brand is being stolen by someone, but you did not register your trademark, how then? What are your remedies? How do you then now bring an action against the infringer to court? So there is this concept called passing off is a common law tort. It's basically something that we have adopted from English law. The fundamental principle surrounding passing off is that no one has the right to represent his goods or pass off his goods as someone else's. In a more layman term, he cannot represent to other people that he is selling someone else's goods. I would like to go through some legal or case law definitions of the concept of passing off. A trader is not allowed to use names, marks, letters, or other indicia by which he may induce purchasers to believe that the goods which he is selling are the manufacture of another person. Traders must not indulge in unfair trading or dishonest competition by misleading customers and to divert the competitor's business. These are some of the things that I will discuss later on how to see whether there is passing off. An action for trademark infringement is different from passing off, though they are complementary causes of action. So in case you want to ask this question later, I'll answer it right now. Yes, you can sue for both in the same suit. These are the basic and most crucial elements that you must prove if you want to say that there is passing off. There must be goodwill, there must be misrepresentation, and there must be damage caused. A plaintiff in an action must prove that he has goodwill at the time the act of the alleged passing off took place. Goodwill is typically attached to a business, arising from, amongst other things, the trademark, if it's registered in the business. Goodwill is transferable via a deed of assignment, and you can assign it together with an unregistered trademark if that's the case. Now, the key element in goodwill is that there must be distinctiveness. The first thing we will explore is descriptive words. Words which are common or generic are not distinctive. Now, let me just give you some examples so that you know what distinctive or descriptive means. The word, Surya KLCC, the word Surya and Surya Sabah. Surya Sabah is actually a hotel in Sabah. So the common word here is Surya. And Surya is a generic Malay word meaning the sun. And Surya KLCC actually brought an action against the company that constructed Surya Sabah, saying that they have the exclusive right to use the word Surya. But the court held that because it's a generic Malay word, one entity should not have a monopoly over a generic word. So you cannot establish goodwill just because you have a name that is attached to your brand that is generic. Now, look at this word Sephora. And let's say there is another company that came up with a makeup brand or a lifestyle brand that says the Sephora. Would you say Sephora is a generic word as opposed to Surya being a generic Malay word for the sun? Would Sephora be a common or generic word? Maybe you can type in the chat and maybe let me see what you think. I don't have an answer. There is no actual case, but I would say that yes, you're right. It is not a generic word. So if ever Sephora brought a case on passing off to say that there is no goodwill or there is goodwill attached to the name Sephora, they might succeed. Now, the other example here would be secondary meaning may exist where the public is able to distinguish a trader's goods or services from the competitors. Now, the word body shop or clean and clear. They are generic words. Do you agree with me? They're all generic words. But if you look at the Body Shop, you know it is attached to this brand. Clean and clear, you know it is attached to that Johnson & Johnson skincare line. So because a secondary meaning has already existed to a generic word, you can establish distinctiveness here. But on the flip side, some distinctive words, if not properly protected, can become descriptive. If your mother say, please go and buy Dettol, or please go and buy Clorox, in your mind, the instruction is, please go and buy antiseptic liquid. Please go and buy bleach, right? So these words have become so common, they become your everyday language to describe antiseptic liquid and bleach. Now, this means the words have lost its distinctiveness, and therefore you may not be able to claim for goodwill attached to this word. These are just examples. Goodwill is also territorial. It must exist in Malaysia. So since we're in a Malaysian context, even if you're a foreign brand, you must prove that you have a customer base in Malaysia, for example. So a businessman could have goodwill in this country, although based on trading carried on abroad. Now, this is quite obvious in the world of internet. There are so many brands that do not actually have a retail presence in Malaysia, but they're well known. They have a huge customer base in Malaysia. And for that, you may be able to claim that there is goodwill established in Malaysia. However, there is an exception to the protection of well-known trademarks. Let me just read out Section 76 of the Trademarks Act. It says here, well-known trademark shall be entitled to protection under this act, whether or not the trademark has been registered in Malaysia. You may be able to show that even if there is no customer base, but it's such a well-known brand that anyone who mentions it, they know what the brand means. Now, let me just give you an example. Can you see the brand on the bottom left? Tesla. Tesla, I'm not sure if there's anyone in Malaysia who owns Tesla yet, but we all know what Tesla is. It's an electric vehicle. However, as far as I'm aware, there is probably not a huge customer base here, but it's definitely well known. So it's arguable, even though they do not have a business or a customer base in Malaysia, it's well known enough to establish that it is a well-known trademark under the act. And for that, Tesla might be able to sue for any act of passing off in Malaysia. Let me just go through Regulation 5 to show you what are the criteria these brands must establish. First, the extent of knowledge or recognition of the trademark, the relevant sector. Using the Tesla example again, everyone knows what Tesla is. Everyone knows it's a very famous electric car. The duration and extent and the geographical area of any use of this trademark. So if it's used in Malaysia, the promotion of the goods. Okay, we may not see the promotion yet, so this may be a questionable criteria. The place of registration, the successful enforcement of rights. Enforcement of rights will be discussed by Leslie later, after this. And the value associated with the trademark. Everything, all of these ingredients will have to be proven. So if Tesla wanted to bring an action in Malaysia, it has to prove each and every criteria named in Regulation 5 of the Trademarks Regulation 2019. So this is, again, if you look at this brand on the bottom right, okay, I don't know how to pronounce it, despite me trying a few times. I've asked some of my colleagues, they don't know what this brand is, but it's apparently a very well-known clothing brand from England. Now, if there was an infringer or someone who passed off as this brand in Malaysia, would they be successful under this section? That is something remains to be seen. Because from my very limited survey, nobody seems to know what this brand is, at least in Malaysia. So this shows that goodwill, it's important to establish that goodwill is established in Malaysia within the Malaysian context. And then the top two brands, everyone knows who they are, but they do all have retail presence in Malaysia. They may not need to go to the extent of proving that they are the protection under Section 76. They can just sue under registered trademarks if they're registered in Malaysia. Those are the few examples. The next element is misrepresentation. There is no need to prove actual deception or confusion. Once misrep is established, it must be shown that it is likely to cause confusion or deception. So the first thing you need to prove is this misrepresentation. Now, the category is very wide. There are so many things that can come under misrepresentation. I will give you some common examples. First of all, there will be confusion as to the source. This is an actual case between the word Microsoft versus micro-soft. A layperson, the public, can look at these two names and wonder themselves, are they the same? Do they all come from Microsoft? So if there is a confusion as to where the product comes from, then you would have proven that misrepresentation has existed. The next one, selling goods with inferior quality. They may carry the same brand, same supplier, but one is a rejected good, but one is actual proper good, So if they are both sold to the market, the person who sells the rejected goods is guilty of misrepresentation for selling goods with inferior quality. This is the example we have taken from this case in Malaysia, where there is an import of rejected goods in one territory, and then you sell it in another territory, which is in Malaysia, where the plaintiff was trading. The next case would be similarity and get up. This is very similar to the example given by Leslie earlier. I took this image from this website where if at a glance you look at it and you would think that they are from the same company, they are selling the same product, probably different packaging, maybe there was a rebranding. That's probably what you thought when you first see at a glance. And then when you see the brand, then you realize, oh, they're actually different. This is an act of misrepresentation in terms of the get up. Finally, you would also need to prove that you have suffered damages as a result of the passing off. These are some of the examples. Let me just read out to you. There will be a loss of sales or profits due to the diversion of business. There is a depreciation of goodwill. There's a devaluation of reputation. And then there's false connection that leads to the disfavor of customers. I think this is the worst, one of the worst ones. Let's say in this earlier example, where you sold the same goods, but there was inferior quality out there. I think one example I can give you is the latest case of Khairul Amin. I think this one, if you know who Khairul Amin is, he is a very famous food content creator. So he sells sambal nyet, that's what it's called. But someone out there actually sold the same sambal, but inferior quality. I remember there were complaints about it going bad or that they taste different. And as a result of that, his business suffered. Khairul Amin's business suffered. Now, this is a very clear case of misrepresentation. He didn't bring the case to court, but it was very well publicized because he demanded an apology from the person who passed off the product. So a false connection leads to the disfavor of the customers is one of the example of damage that Khairul Amin in this example has suffered. And evidence obviously is something that you have to prove. And in this case, monetary evidence would be the most obvious. Finally, let me just show you an example of a very recent case of Muhammad Hafiz bin Hamuddin versus Khamdar. This was a federal court case where there's an appeal by the appellant concerning the sale of the respondent of certain goods bearing the label Hafiz Hamuddin. So Khamdar, if you don't already know, sells fabrics. Appellant is an artist who incorporated a company for the purposes of trading in fabrics. So both companies sell fabrics. One is Khamdar, and one is the company that was set up by Muhammad Hafiz. So one day, Muhammad Hafiz received a lot of messages from people asking if the fabrics sold by Khamdar under the label Hafiz Hamuddin were his. So I was curious to see what exactly it looks like. This is the fabric that is sold by Khamdar. It says at the bottom there, Hafiz Hamuddin Kain Melayu Shine. And obviously, in this case, Hafiz is saying, no, I did not I'm not selling it under Khamdar. If anything, I sell it under my own company. The appellant asserted that by selling the products with the same label, the respondent passed off the unregistered trademark of Hafiz Hamuddin. So this is the case where there is the name, his name was an unregistered trademark. The argument by Khamdar was that if there was any goodwill, it belongs to the company which Hafiz set up, not he himself. There was an issue about who should have been the person to sue Khamdar. The court held that the goodwill in the name Hafiz Hamuddin belonged to the appellant and not the company. The unregistered trademark was identified with the appellant. But the court also went on to explain that there was an implied license between the appellant and the company he founded to sell fabrics. The defendant was a third party, and there is no business using this unregistered trademark without consent, by which it had generated profit through deception. The court further held that Hafiz Hamidun is a celebrity who had amassed goodwill, much in the way the plaintiff had in this appeal was the owner of such goodwill. Members of the public, comprising the fans, were led to believe that the goods were sold by the defendant under the name. There was clearly deception on the part of the defendant by misappropriating the goodwill, and the plaintiff had to explain that his name was used as the label for his product under his company. I think that's pretty much it for passing off. I hope you have learned something today. Leslie, over to you.
Hey, thank you, Hannah. Now that we've already touched on what amounts or what could possibly amount to infringement of trademarks, as well as gain an understanding about passing off, we're going to move on to enforcement of exclusive right. And that exclusive right is basically derived from registered trademarks. And there are lots of advantages and importance in registration. First of all, is the creation of an asset. If you recall the first slide at the start, I mentioned about how IP can be a valuable asset. So really, IP is a creation of an asset. Registration allows the proprietor to enjoy protection for 10 years. You can use the registered symbol. Here, exclusivity. So as the proprietor, as the owner of that mark, you have the right to assign, to license, and to franchise. And through that process, your business, your company can generate commercial value, have financial gains, and indirectly build goodwill and reputation as well in the market, in the industry. And then the last point you see over there, as the proprietor and as the owner, you also have a right to protect your brand and your mark against abuse and misuse. And this is where infringement comes in. So Section 16 reinforces the notion that an IP or a trademark is a property right, and that as a registered proprietor is entitled to rights and remedies as provided under the Act. It also says it's a movable, personal and movable property. And here, Section 48 says that these are some of the rights that are accorded exclusively to a registered proprietor. First one, to use the trademark. You can authorize someone else to use the trademark, and that's where you have the licensing, the assignment, and the franchising. And there you see over sub 2 at the bottom is the right to obtain relief for infringement. So what sort of infringement or what sort of relief can a proprietor seek? And there are 3 avenues here: civil proceedings, criminal action, or border measure. The first one, civil proceedings. The first thing to know when it comes to civil proceedings is that notwithstanding that the registration process is done through MIPO, which is the Intellectual Property Corporation of Malaysia, when it comes to infringement, MIPO is not going to come into the picture to assist. This is a step which the registered proprietor needs to decide if he, she, or the company wishes to take. So that's the first thing. And usually the process starts with the issuance of a cease and desist letter. If you remember the example I mentioned earlier, the plaintiff started with the issuance of a cease and desist as well. And Section 56 provides a right to institute court proceedings. And here are some of the reliefs that a proprietor can seek: injunctions, and the court actually has the discretion to declare certain conditions, such as preventing the goods involved in the infringement from entering the channels of commerce. You can seek damages, accounts of profits, order for erasure, delivery up or disposal, or even interim injunctions. So here's a case which I'm sure back then most of us read in the newspapers. It's Lakafa versus Loop Holdings in relation to the very famous Cha Time. So Lakafa is a Taiwanese company that was founded in 2005. They are the first public listed company in Taiwan to make a name for themselves selling these pearls in bubble milk tea. And in 2010, they started a franchise relationship with Loop Holdings. And once that franchise relationship started, we started seeing Cha Time outlets appearing all over the malls in Kuala Lumpur and across Malaysia. And that contract between these two parties was supposed to run up until 2041, very long contract. But in 2017, early 2017, the Taiwanese company terminated the agreement because they discovered that Loop Holdings over here in Malaysia was purchasing their raw materials from a third party instead of from Lakafa, as required under the franchise agreement. And also there was an outstanding amount from Loop to Lakafa of about $600,000. And so pursuant to the agreement, Lakafa started arbitration proceedings in Singapore, but at the same time, Lakafa filed proceedings here in Malaysia seeking for 3 interim prohibitory injunctions and a mandatory injunction against Loop. So here we'll look a little closer what were the prohibitory injunctions that Lakafa sought to seek from court. They sought to restrain Loop, its directors, including spouses and immediate family members and employees, from carrying on a business which was similar or identical to Cha Time, from disclosing confidential information that had been procured from Lakafa during the terms of the business agreement. They wanted to restrain Loop from interfering with Lakafa's rights and obligations to render operations consultancy to the other franchisees of Cha Time. And they also wanted to restrain Loop from passing off Lakafa's goodwill and reputation in the Cha Time franchise. These prohibitory injunctions were not granted by the court because the court held that it failed to see how such an interim measure could assist the arbitration proceedings that was going on in Singapore. And additionally, the court also found that damages were an adequate remedy. Other than the prohibitory injunctions, Lakafa also sought for mandatory injunctions, and they sought to compel Loop, again with the directors and employees, to return to Lakafa all materials related to Cha Time's trademarks and proprietary information belonging to Lakafa. And this injunction was granted by court because the court found that Lakafa had a strong and clear case, because when the court looked at the terms of the agreement, the court found that there were grounds to grant this injunction. So there was a long fight between these two companies, about 1.5 to 2 years. And the conclusion of it was that the parties actually came to an out-of-court settlement, whereby part of the terms was that parties would agree to withdraw all proceedings against each other in all jurisdictions, so both in Singapore as well as Malaysia. Here's another example. This company called Masitu Marketing, they own this mark called Mass Foam, and they they produce foam products. I put one there on the bottom left. I've taken it from their website. That's what foam products that they produce. And the defendants also decided to get involved in this business of manufacturing, producing, and selling similar foam products that were very similar to Mass Foam. And then sometime in March 2019, Masitu discovered that there was these products that were being sold in the market by the defendants. And a couple of months later, the plaintiffs decided to institute a claim for infringement as well as for passing off. And sharing with you some of the judgment from the court, and the court held that yes, the infringed goods were being used without Masitu's consent. There was definitely deception and confusion among potential buyers. The court held that there was passing off and that there was infringement. And what the defendants did was, not only did they sell the products, one of the defendants even held himself out to be a representative of Masitu. And the mark that they were using, the defendants, was not only visually, but phonetically identical to Masitu's mark. Here, court went on to hold there was misrepresentation. If you remember the elements that Hannah shared just now, goodwill, misrepresentation, and damages. Misrepresentation is one of them. Court established that there was misrepresentation. The Mass Foam was being used on invoices, purchase orders, Facebook page, and that this is likely to divert the plaintiff's business and will injure their plaintiff's goodwill. And in this case, the plaintiffs also sought for the following reliefs. They also sought for a mandatory injunction to compel the defendants to change their name and remove mass foam entirely from it. And they also sought for an injunction to restrain the defendants from continuing to infringe and from passing off and attempting to pass off the defendants' goods as that of the plaintiffs. Now, other than civil proceedings, the Act also provides for provisions for criminal action. So there's a whole section in the Act. So you see counterfeiting a trademark and a whole host of other sections. I'll just very briefly show you what Section 99 says on counterfeiting a trademark. So if a person counterfeits a registered trademark, which means he makes a sign that is identical with or similar, or falsifying a genuine trademark, whether by alteration, addition, effacement, partial removement, etc. In general, it is an offense, and usually upon conviction, the liability is by way of a fine or by imprisonment. So under criminal action, most of it generally is either a fine or imprisonment. Now, the third relief that's provided under the Act is border measures. So when it comes to border measures, the parties that are involved is the registered proprietor, or if the registered proprietor has assigned or licensed out their usage of their mark, then the party involved will be either a licensee or a franchisee. The other party that's involved is the registrar. I put it in red, you will see at the bottom. And the last party that's involved in border measure is the customs officer. So how this border measure works is that any person, which is either the registered proprietor, the licensee, can file an application to the registrar. And in the application, the proprietor will then specify a time and place in which the infringing goods are expected to be imported for the purposes of trade, and that the proprietor is saying, I'm objecting to this importation. This application has to be supported by documents, information, so that the registrar can then determine and identify together with the authorized officer. And of course, there's a payment of a fee involved. Again, there's a whole portion in the Act which deals with border measures. The last one I'll just touch on is, I think there might be a question on what kind of size of the imported goods needs to be. And the Act provides for that. It says that it doesn't apply to small quantities of goods of non-commercial nature. So, if you're coming back from Korea and you bring a whole bunch of skin cream for the whole of your family, don't plan to sell it, doesn't fall within here, or contain in your travelers luggage or small consignments, you order big delivery from the US. But in general, we're talking about more than 2. So it's 3 or more. Anything that's 2 or less doesn't fall within these provisions. Now, we've spoken a lot about enforcement of rights, but if you have a registered trademark, it's also important to take steps to maintain those rights. And I've got 2 examples here. So here is, and you'll see that these 2 examples are sort of different approach. So here you have McDonald's. This is their USA website. I've taken it from their USA website. And you see the way they phrased it here. They say, interested in using our logo for your next project, put in your request and your permission here. And they've got a form for you to fill. So here they're saying that, okay, if you want to use, we're opening the doors, come approach us, let's talk about it. Now, this is another brand that might be unfamiliar to some of you. It's a brand called CrossFit. It is a fitness brand established in the US. And it's a fitness methodology made out of functional fitness, Olympic weightlifting, and gymnastics. And they've grown their brand globally. And what CrossFit has done is they have registered their trademarks in many countries across the world. And they have a form on their website which says IP theft form. And this form instead is that if you see a gym using the word CrossFit and it's not properly licensed, this website allows you to actually report that usage, and then CrossFit will then take steps to enforce their rights over here, say in Malaysia, for example. So 2 different approaches. You see McDonald's saying that, hey, if you want to use my trademark, here's the form, fill it in. Here on the other side, the flip side is that they've got a form, CrossFit has got a form where you can actually report IP theft. So my other slides are just an example of what the form is like. You can fill in all the details, and then you can put in all the details about the infringement as well. So it's a reporting form instead. This is the last point, defenses available to an alleged infringer. Hannah's going to take this and she's going to wrap up the talk, and I look forward to taking your questions at the end of the session. Thank you very much.
We now go to the section where we discuss the defenses available to an alleged infringer. So this is especially for those of you who are possibly facing, or maybe in the future, you never know, an action for infringement. We look at 2 sections. First is Section 55 of the Trademarks Act. Section 55 says that a person does not infringe a registered trademark if he uses the mark in good faith. This section basically sets out if he uses in good faith a sign to indicate the kind, quality, quantity, purposes, and others of the mark. This is a case where, notwithstanding the infringement section 54, a person does not infringe a registered trademark by using an unregistered trademark that is identical with or similar to the registered trademark if he has continuously used from time to time goods and or services from a time before the date of registration. So if this is something that he has already established, quote unquote, goodwill on before the date of the registered trademark, and the date of the registered proprietor first used the trademark, whichever is earlier. So there will be no action against you if you've already used it earlier than the registered trademark. Notwithstanding anything contained in this act, a person who uses a registered trademark does not infringe the trademark if it is used for non-commercial purposes, it's for the purposes of reporting or commentary or news, if there is impliedly or expressly consented by the registered proprietor or licensee, and of a trademark which is one of two or more registered trademarks which are substantially identical in the exercise of the use of the right to use of that trademark given by registration provided at the Act. Essentially, this means if it's used by permission under the Act. So breaking down the language of the section for you. We now look at section 61. Now, if you are a person who are facing an infringement proceeding and it's completely groundless, there is no basis to that threat or that, that allegation, you also have remedy under the section. So where a person threatens another with proceedings for infringement of a registered trademark, the application of a trademark to goods or to material used or intended to be used for packaging or labeling, the importation of goods to which or to the packaging of which a trademark has been applied, or the supply of services under the trademark, an aggrieved person may bring proceedings for relief under section 61. So these are the reliefs that you may apply under section 61. A declaration that the threats are unjustifiable. This is a declaration from court. That injunction against the continuance of the threat and damages for any loss that you have suffered as a result of the threat. Mere notification that a trademark is registered or that an application has been made is not a threat of proceedings. So if someone tells you, hey, I am registering my trademark, that is not a threat of infringement. They're not saying that you are infringing a trademark. And now I will conclude our discussion today. So as Leslie has mentioned earlier, that little r holds a lot of power. Register your mark is the first step in establishing infringement. So if you have done business for a very long time and you feel like there are more and more counterfeit products in the market, I think the first step you should do is to go ahead and have it registered. Although you have passing off as a remedy, remember passing off can still be brought together with an infringement proceeding. So the first step, the safest, the most surefire way is to have it registered. Then you renew your trademark. Once you register, don't sleep on your rights, don't sleep on your trademark, have it renewed. Use your trademark extensively in your business. It has propriety, right? And it has a lot of value to it. Use it to expand your business. Okay? Defending against trademark infringement proceedings can be costly and disruptive to your business. As we have mentioned earlier, get your trademark registered, even though there are defenses available under the Act. We are done.
Yes, we can move on to
Yes.
Q&A. Caroline, I can start with Jasmine and Mr. Tarumaraja's questions, and maybe Hannah can take the questions on passing off.
So Jasmine has asked, what is the difference between TM and R? I'm assuming this is for the logo that we usually see at the end. So,
Yeah, I do realize the examples we've given have a combination of the two. So TM is used to indicate that a trademark application has already been submitted and applied for, but the time frame between submitting the application and actually getting the registration certificate can sometimes take a while. So sometimes companies use the TM just to indicate first. And then once they get the certificate of registration, they then are allowed to use the R instead.
To the next question, can a manufacturer be held liable for passing off of the products? Mr. or Miss Anonymous, the answer to this is that whether anyone can be liable, not just manufacturer, whether anyone can be liable for passing off really depends on the three elements. So if a manufacturer, if the person who brings the passing off action can prove that the manufacturer is misrepresenting the products, then yes, there is a chance that passing off can be established. Now, if you are just a person who's doing the white labeling, just labeling and selling on behalf of someone, the actual person who is giving you instructions to sell, then you may be able to defend yourself against these proceedings, saying that I did not misrepresent. It was not me who put out the advertisement for this product, for example. So the question is really not just manufacturing. Can anyone be held liable for passing off? And the answer is you just need to look at that three elements and see if all three are fulfilled. If yes, then yes. If no, then no.
Let's take Mr. Tarumaraja's question, because in all fairness, he put it in at 3:08, so he's been waiting 50 minutes for us to answer his questions. Sir, you've asked if should a compound be paid, and if so, will it affect a pending civil action? I believe that there are two separate causes of action, two separate reliefs. If there's a compound, obviously our advice is to pay it. I don't think it will affect a pending civil action, because the reliefs that are sought under civil action, as I shared just now, injunction damages, order for erasure, delivery up, the reliefs are different. That will be my answer to your questions.
What if the inferior quality goods were sold with a disclaimer by the party selling? Will the brand owner be still liable to sue, and will the buyer, upon knowing, decided that he or she felt unsatisfied and decided to take it to court? I see two facets to this question. One is a suit by the brand owner and one is a suit by the consumer. I'll go to the consumer one first because, well, it's not really directly related to trademark. If you are a person who has been aggrieved by an inferior quality of product, there is an action in tort that you can bring against the person who sold those goods. That's not strictly a trademark issue. As to the brand owner, will you still be able to sue? Now, if you are suing by infringement proceedings, a trademark can be registered with a disclaimer. And if that's the case, then you may not be able to succeed in an infringement proceeding because trademark can exist with disclaimers.
Mr. Soon On, I hope I got your name right, has asked, what are your thoughts on McDonald's and McCurry? Yeah, interesting question to end our session today. McDonald's, my favorite fast food brand, and exactly that. McDonald's is known for fast food. The golden M, it's called the golden arches, is distinctive. It's a very well known and established. And I think first, if we look at, no doubt both are food, but it's very, I guess in my view, there's a certain distinctiveness in terms of when you talk about McDonald's, it's clearly fast food. Whereas when you talk about McCurry, I think the immediate thought that comes to mind is that it's probably related to Indian food. So that's the first distinctiveness. And then I think the second one is in terms of the logo, the golden arches, as I was saying. And then, yes, I think McCurry has some similarities. They've used the same red color, the way they capitalize the M and the C. There are some similarities, but I suppose the court found that there is distinguishedness between the two, something distinctive between the two, as compared to, say, the first example I gave just now with the chocolate chip cookies. Not just food, not just cookies, but chocolate chip cookies in particular. You see how similar that is as compared to food. One is fast food and one is Indian food. So I think that's my answer to Soon On's question.
Thank you so much, Leslie and Hannah, for your insights, for a very interesting talk. Before we conclude, I just have a few announcements to make. First of all, please join us for our upcoming talk. It will be held on the 20th of April. We are on minority shareholders' rights in Malaysia. You can also scan the QR code on the screen to sign up for our online talk. Secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. Thirdly, do follow and like all our social media accounts. We are on YouTube, Twitter, Instagram, LinkedIn, and Facebook. If you would like to speak to any of our lawyers, we offer a complimentary 30-minute consultation. over the telephone or over video conference, please fill in the form on our website. The link is posted in the chat box as well, or you can scan the QR code that is currently on the screen. To all of our guests, thank you so much for joining us. We hope that you found today's session informative and useful. Thank you, everybody, and we hope to see you at our next talk.